I got it for 6:30, 6:32, 6:34, 6:36.
Oh, here's the thing.
That's how I have my alarm.
This is the thing. I'm not in charge of your alarm clock, but I'm going to recall the warrant and you had better be in here tomorrow on time
be an
at
hour
9
early.
a.m. The case we just completed, Mr. Sanchez.
Your Honor, do you want to talk to Hernandez?
Yes, let's bring him out. Hello.
Hello, miss.
Hey, I heard you fell out in the back when they were taking you to custody,
Yes,
throwing yourself on
ma'am.
the floor. Well, here's the thing. Throwing yourself on the floor crying because you've been taken into custody, you know what that results in?
That makes me look like a little girl.
No, I mean, excuse me. Do not say bad things about little girls. That's saying something bad things about little girls because little girls don't do that. But you know what ends up happening when you go in the back and you throw yourself on the floor? You just on a dirty floor.
That's true.
And then you know what ends up happening? The deputy calls somebody and this deputy and the other deputy, they just will drag you out. Now, why were you late for court this morning?
I'm actually on some medication right now that's supposed to help me for my anxiety and depression and other stuff. And I actually had my alarm set for 6:30 a.m. this morning, so I can go ahead and shave this little bit off, take my shower, get some breakfast, and actually be here an hour early.
All right, so let me give you a hint. This is what you have to do, and this is what I do. If you know,
I have 2 phones with the alarm.
here's the thing. They didn't work for you
They
today.
didn't miss, and I woke up this morning mad.
So this is what you need to do. You need to set your alarm and set it in increments, because this is what I've discovered from some people. Some people, the alarm goes off, then they hit the snooze and they continue to hit the snooze. I'm recalling this case for tomorrow, and guess what? You better be on time.
I got it for 6:30, 6:32, 6:34, 6:36.
Oh, here's the thing.
6:38. That's how I have my alarm.
This is the thing. I'm not in charge of your alarm clock, but I'm going to recall the warrant and you had better be in here tomorrow on time
be an
at
hour
9
early.
a.m.
I'm gonna be an hour early, miss.
Oh,
I'm
well,
gonna
if
be
you're here an hour early, which means you'll be here at 8,
I'll be
just
here
sit
at
on the
8.
bench.
I'll sit on the bench.
And you know what? If you're sitting on that bench, when these doors open, you better be in here.
I'm gonna greet you in the morning, miss.
Well, I mean, don't greet me. The deputies will get concerned about that, but all right. Norma, if you can give him a reset form for tomorrow at 9 a.m. Court is calling 2020 CR 3270, State of Texas versus Joe Anthony Thomas. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Adam LaHood for the defendant.
And are you Mr. Thomas?
Yes, ma'am.
I know that there's been some time from when we started this hearing to now. The court has been in jury trial on 2 separate cases since that date. So you entered a plea of not true to number 1 and number 5. Everything else was waived without objection. And where we left off, there was an exhibit that was admitted, which was a video. All right. And the person who was on the witness stand was Officer Erdman.
Yes, Your Honor. And so I've conferred with defense counsel. I've made redactions to that video that's already been admitted, and I'd like to publish those at this time.
We have no objections as to that redacted video, Judge.
All right. And what's the exhibit number?
Mark them yet, Judge. Do we have, I guess 3, or we to 3? Is that it?
I will have to look through my notes.
I believe it's going to be 3, Judge, because I believe the drug ID report is 1.
Just one moment.
Yes, ma'am.
Remember, don't talk away
Oh, sorry.
conversationally from the court reporter. So is there any objection? There was no objection to State's Exhibit number 1, correct?
No, Your Honor, we stipulated.
All right. And then with regards to State's Exhibit number 2, which the court has previously seen.
We're not objecting to that either, judges. The redacted portion of the video, which is a statement made by Mr. Thomas, which is admissible.
All right. So State's Exhibit number 1 and number 2, just in case there was some confusion, those have been admitted without objection. And then your other exhibit, counsel?
Yes, Your Honor. I have State's Exhibit 3 and State's Exhibit 4, and those are both portions of Officer Erdman's body-worn camera. And they've, the defense counsel and I have looked at these together. They're different statements that the defendant made on the body-worn camera. I'd just like to publish them to the court.
All right. Any objection to State's Exhibit 3 and 4?
No, Your Honor.
All right. Then State's Exhibit number 3 and 4 are admitted.
Can I use the, do you want me to put them back?
Yes. Do you have the
The drive?
Yes.
ma'am.
You won't be able to see them and just share.
Okay, I will. Thank you. See, you are the tech person.
You want me to come around, Judge?
Oh, I have it.
So just to give the court some context, the portions that are muted are, there's a part of the video where Officer Erdman says you're under arrest, and so we're not trying to play anything after that. This is all before that, Judge.
All right, so the exhibit that you've given me, what exhibit number is that?
That's number 3, Judge.
All right, State's Exhibit number 3, and are you asking that that be published?
Yes, ma'am, and if we could go to.
Just one
Yes,
moment.
ma'am.
Second, let me pause.
Actually, it's like nutrition snacks.
Okay,
On the top right, Judge, what we're trying to get to is 0103. The rest of it should be muted.
It's about 30 minutes ahead, I think.
Yes, ma'am. Just about 5 minutes.
okay, here we are.
Yes, ma'am.
In just one moment. Let me do this. Just 1 second. I want to make sure the audio is on. Okay, it is. Should this have audio, this portion, or no?
No, ma'am, in about 1 minute.
Okay.
But I don't know if it's worth kind of clicking ahead because we're just almost there.
Why?
Because you're under arrest.
Am I under arrest?
Yes, you have
Am I
coke in your
being
car.
detained? No, he just said I'm waiting for.
All right, and I'm telling you, you had coke in your car. You're under arrest. Stay seated. Stay quiet. They'll read you your rights when they get here, and they start questioning.
Did you have authorization to go in my car?
Yeah, because you're under arrest.
Okay, so that's that portion, Judge. I believe that the rest of it should be muted.
Okay,
And then this is exhibit 4.
all right. All right, and this is State's Exhibit number 4.
Yes, ma'am. So on this one, Judge, we're trying to go to 35 minutes.
Okay.
So just about 7 minutes. I did these out of order, I'm sorry. Judge.
Oh, no, no problem.
This was earlier in time than State's Exhibit 3.
All right, we'll start it at 34:04.
What's that white shit that was in your driver's side?
2230, I just talked with
Tell us now, because we're gonna find out anyway.
You're gonna find out either way.
Yeah, but it helps with getting a test kit for it.
Hey, you're gonna find out either way.
All right.
I have your
This wasn't even my fault. I accidentally.
And that's all we wanted to play, Judge.
All right. All right, any other questions for Officer Erdman?
I'm not sure where I got to in my questioning of the officer. I know,
You can start wherever you want to start,
Okay.
yes.
so Officer-
And just 1 second, Officer Erdman, you're still under oath?
Yes, ma'am.
All right, state.
Officer Erdman, so when you were, were you able to hear those excerpts from your body cam that were displayed?
Yes, sir.
Okay, so, in the second clip that we watched, what are you trying to determine from the defendant?
What the substance was that that I found in the driver's side door of the arrested person's vehicle.
And why did you believe it was his vehicle?
It was pointed out to me that that was the vehicle.
Objection, hearsay.
Sustained.
And what are his response to you? What did you learn anything from your question?
He was just saying that I'll find out what it is anyway. So at that point, I just got an evidence unit to test the substance.
And in the first clip that we watched, in State's Exhibit 1, were you questioning the defendant at that time?
Was that the clip from today, the first video?
Yes, sir.
No, I was not questioning the defendant at that time.
I don't have any further questions, Judge.
Yeah,
Defense.
of course. Officer, is it Erdman? I'm sorry, my eyes are.
Yes, sir.
Okay, my name's Adam LaHood. I don't know if you can see me on camera. I'm the defense attorney.
Oh, if you come over this way, he'll be able to see.
There we go. How you doing today, sir?
I'm doing well, sir.
All right. I just have a few questions for you. Did
Yes,
you
sir.
ever observe the defendant, Mr. Thomas, who's saying here, driving the vehicle?
No, sir.
Did you ever observe him in the vehicle?
No, sir.
Did you ever observe him possessing narcotics in his control?
No, sir.
Pass witness, Judge.
No further questions, Your Honor.
All right, is this witness excused?
Yes.
Excused?
Yes, Your Honor.
Thank you so much, Officer Erdman.
I appreciate your
And-
time.
You're welcome, and you will not be needed for tomorrow or any other day.
Okay. Thank you.
All
Thank
right.
you.
Thank you.
Bye.
Bye-bye. All right, any further witnesses state?
No further witnesses, Your Honor.
Defense, any witnesses?
Your Honor, we'll rest without calling witnesses, just argument.
All right, the court will hear argument, state.
Your Honor, we're asking for revocation in this case.
Well, let's go back to the true, not true portion. So he pled not true to violations 1 and 5. If you want to address those. And if parties need a chance to get their thoughts together, I can take up this motion to revoke and then you all can get your
I just
thoughts
want to-
together.
I just want to see what number 5 is. I remember number 1.
Do y'all need time to get your thoughts together?
I think I'm ready, Judge.
Okay,
So on violation of condition number 1, we heard testimony from the officer, and we saw his body cam, we were able to hear his body cam. In that first, in State Exhibit 1, when the defendant asks, did you have authorization to go in my car? I believe that's a statement that the defendant made, not in response to questioning, he's just volunteering that information. And I think a reasonable inference that you can make from the testimony that you heard and from the body cam is that the car he's talking about is the car that was searched. And what was found in that car was the cocaine, or I'm sorry, was it cocaine? Was cocaine, Judge. And then the in State's Exhibit 4, when he says, what's the white stuff that we found in the driver's side of that vehicle? When Officer Erdman asked the defendant that, and the defendant says, well, y'all are going to find out anyway. And so I think it's a reasonable inference from what you've heard today, Judge, that the defendant was in possession of a controlled substance in violation of condition number 1, Your Honor. So we're asking that you find violation of condition number 1.
and with regards to violation of condition number 5?
Violation of condition number 5 is about a firearm, Your Honor, and I'm looking through the body cam for that witness. He didn't address that the night of, so I don't have anything to bring to the court to support that violation, Your Honor.
All right, so with regards to violation of condition number 5, the court is finding that not true. And I'll hear argument with regards to violation of condition number 1.
Yes, Your Honor. So, Judge, as you know, I try to be pragmatic and don't waste time. We're not contesting the fact that it was narcotics. We stipulated to that. What we have a serious issue, though, is that the state has a proof problem, namely the fact that this officer and any information he gathered was a result of hearsay. Our argument from the very outset of this hearing, I think a couple weeks ago to now, is that it may be possible to prove the allegations, but not through this officer. I asked him, I think, 2 or 3 questions on cross-examination. Did you ever see him possess of drugs? No. Did you ever see him in the car? No. Did he ever admit to owning drugs? No. They have a proof problem. Again, we'll stipulate that what they found was narcotics. I'm not going to contest. I didn't want to waste the court's time with that. That's why we stipulated as to the lab expert. What they have absolutely failed to show, what they have failed to prove, is that Mr. Thomas was in possession of narcotics, even that it was his car. They're trying to kind of backdoor or, put a square peg into a round hole, if you want to say, saying, well, you'll find out, you'll find out, I guess, eventually. Judge, this isn't an admission by any means. Based upon that, and even with the lower burden of proof, Judge, I believe the state has failed, and we asked the court to find the allegation not true as to count 1, simply for the fact that they don't have a witness to prove possession, which is absolutely necessary for this case.
Okay. All right, so this is what I'm going to do. I'm going to re-listen to the videos because honestly, that's what this comes down to, what was in the videos and what was heard. And I know you're saying you heard something differently than what the court heard. So I'm going to play the videos again, and then I'm going to give you my decision. So if I could have the exhibits.
And then I've got some notes. Hey, Adam.
What's up?
Take a lead. So
Okay,
this is
but-
when.
Oh, that's fine. The timestamps.
Yeah.
Yeah, that make, oh, I actually turned this off, Judge, sorry.
No
Yeah,
problem.
there's timestamps on there for the sake of expediency. It goes to tell you, I guess, where to start watching.
Okay. Thank you. Yes. Oh, I need. You've given me the other ones. Okay, yes. All right, just have a seat and I'll get right back to you. All right, the court is calling 2021 CR 8085A, State of Texas versus Luke Matthew Cantu. Do I have parties announced for the record for the state?
Ryan Groomer for the state of Texas. James Murad for defendant Luke Cantu.
And are you Mr. Cantu?
Yes, Your Honor.
All right, Mr. Cantu, on April 5th, you entered a plea of no contest. According to the plea bargaining agreement, punishment is to be assessed at a cap of 10 years in the prison. There is a $1,500 fine, and the state opposes your application for community supervision or deferred adjudication. This is to run concurrent with 2021 CR 8083. There are several cases that are being taken into consideration. And there should be no contact with James Glenn, GLEN, and Jacob Noble, NOBLE. Are both parties ready to proceed with sentencing?
Yes, Judge. Yes.
All right, state you're opposed.
Yes, Judge. Judge, we just have argument, Judge.
All right, defense, do you have any witnesses?
No, Your Honor.
All right, then we'll proceed, state with your argument, and then Mr. Byron will proceed with you afterwards.
Judge, the biggest thing I'd call your attention to, Judge, is his criminal history, Judge. Mr. Cantu, almost every single offense he has picked up has been something involving stealing from someone else. It dates back to 2009. He's never been successful on probation ever in terms of his felony offenses. And in addition, he has been to prison before for the exact same thing that we're here today. Judge, at some point, he just can't stop stealing. He's been to prison for 7 years for burglary. And here we are back again with more thefts. In this particular case, we have 3 thefts. We are asking for 10 years because last time he did 7 years on a burg. And that wasn't able to reform his conduct. We believe that 10 is appropriate based on his criminal history and the facts of these cases.
All right, and I'm assuming both parties have had a chance to review the PSI report?
Yes.
State?
Yes, Judge.
All right, Mr. Meyer?
So, yeah, much of what state has highlighted concerning Mr. Cantu's criminal history is accurate. He does have a lot of property crimes, theft crimes, burglary crimes, and seems that it's just been trailing him since the last 14, 15 years. With a trip in the pen and a trip in the state jail. And what's different now is he's 37. I think he's come to the realization that, well, I think when you look at property crimes don't happen without a reason. They happen because they're being fueled by some serious drug use. I mean,
But sometimes, isn't that just a person's occupation? My occupation is I steal. When people go to work, I break into homes. That's my occupation.
No, that's not his occupation. His occupation is, well, in fact, what happened in this instance, he was actually working, sending out flyers door to door to hotel rooms for pizza coupons, I believe. And he found an opportunity where some doors were not secured, entered into hotel rooms, taking items, pawning them off. And there was not a whole lot of police and resources necessary to find that he had been linked to the burglary. He was actually very forthcoming and cooperated with detectives and police to essentially turn himself in without too much trouble. But no, to answer the question, his occupation is not a thief. His occupation is a person who's trying and needing to get help to rehabilitate his very bad, very, very serious drug dependency problems. We're talking about, ecstasy, cocaine, and meth, heroin daily. If granted the probation, we certainly, Mr. Cantu is seeking inpatient help and treatment at the state facility to get rehabilitated, to seek drug treatment. He's, I think, admittedly thinks that at this time maybe he's not ready for engagement for police at home or anything. I think he understands that, but I think he does not need. Admittedly, I think in his PSI as well as his TAPI Valley was very honest and about that he does need patient health. But yeah, no, I mean, I think property crimes is a byproduct or the result of serious drug dependence problems.
I mean,
Some of which-
sometimes it
sorry.
is, sometimes it's not. Sometimes that's what people do for a living because it's easier to break into homes and break into places as opposed to getting a job. That's why you have some people who burglarize in the daytime because they know other people are at work. But Mr. Cantu, what have you learned? Because you had a theft case in 2007 and you were placed on deferred adjudication for 12 months. Why did you commit that theft?
Because I was in my addiction at the time and I wasn't ready for any kind of rehabilitation. Man.
So they gave you deferred adjudication and you didn't follow through because I'm sure that when they gave you deferred adjudication, they offered you drug treatment.
Not that I'm aware of, no ma'am.
All right, so then in 2008, you were placed on probation for 2 years for theft, 500 to 1,500. What did you learn on that probation?
Nothing, Your Honor. Again, I was in my addiction at the time using drugs. I've been using drugs almost for about 15 years. And I think that's been my letdown and my fallback in society is my drug habit. It's something that I know that I need to work on. And I kind of give up.
2009, you committed evading detention. You did jail time. That was February. June 2009, you had a resisting arrest, search and transportation, you did jail time. You also had an evading detention. February 22, the resisting arrest being taken into consideration. Then on April 14, 2009, you were given deferred adjudication for theft under $1,500 enhanced. And I know that you were probably offered drug treatment. So when you're on deferred adjudication or on probation and you have a drug problem, because they do UAs on a regular basis.
Yes, ma'am.
So did you take advantage of drug treatment then?
No, ma'am. I think what I needed at the time was some kind of inpatient intensive treatment.
Did you ask for it?
Yes, ma'am, I sure did.
And I'm sure if you asked for it, they would have given it to you.
I did ask for it, and it's something I wasn't granted, but it's something that I need. I know I do need inpatient treatment, something that I need to.
All right, then we have March 2012, burglar habitation for 7 years. April 2012, and I'm assuming all of these were running concurrent because it's all 7 years. So you had burglary with intent to commit theft, a separate case. So those two are run concurrently. And now we're here for more thefts, burglary habitation fourth and thefts. I don't think there's anything that I can do to help you. What I can do is I'm going to deny your application, but they do have a therapeutic community at the prison. And if you want help, they can give you help. However, if you don't ask for it, me requesting it is not going to mean anything. I can't force them to put you in the therapeutic community, but if you request it and I request it, then they may put you into it. Do you understand?
Yes, ma'am.
All right, so I'm going to deny your application. So punishment is a cap of 10 years. State you're asking for 10.
Yes, Judge.
Mr. Meyer, what are you requesting?
Well, I'm requesting obviously lower than the 10. Look, I think we need to just focus on Mr. Cantu's rehabilitation and if there is an opportunity that he can rehabilitate in a TDC facility, giving him tools and skills to overcome drug addiction, we ask the court make a sentence in which that would allow for the period in which he can get that help in the TDC facility. So therefore, I'm asking for a sentence between 2 to 10, but of course in the court's discretion.
Mr. Cantu, what do you think you deserve?
I deserve whatever it is that you feel you need to do with me, Your Honor. I know I've done a lot of wrong in life. I understand that, and I'm ready at the point to where I'm tired. Even when I was out there in my addiction, Your Honor, I was tired, but it was just so hard for me to get out because I was so far into being a heroin addict and a drug user that I couldn't find myself to find any kind of treatment, to find myself any kind of help at the time. I was just so far into my addiction. So whatever you feel is appropriate for me, then that's what I have to go with, Your Honor.
All right, then the court is finding you guilty. The court will sentence you to a $1,500 fine, time and money to run concurrent. I'll request for you a therapeutic community. This is run concurrent with 2021 CR 8083, taking consideration 2021 CR 8070. County Clerk cause number 678886, NIMAG number 649008, CM number 96156. There's to be no contact with James Glenn and Jacob Noble. I'll send you to 8 years in the prison, and of course you'll receive credit for any time served. Mr. Cantu, when you're released from prison, I always know that people have plans, right? When they get out of jail, when they're placed on probation, they say they're going to do everything and get their life in order. But what I've seen in my short time on the planet, even though I'm old, I consider it a short time on the planet, is that sometimes those ideals fly out the window. But when you're released from prison, the first thing you need to do is you need to get in touch with someone to help you with your drug addiction. And usually when you release from prison, sometimes they'll send you to a halfway house to help you with that. You need to make sure that you take advantage of that, okay?
Yes, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Oh, and also in 2021 CR 8083, I'll sentence you to 8 years in the prison, credit for any time served, the therapeutic community, $1,500 fine, time and money to run concurrent. All right, concurrent with 2021 CR 8085A, taking consideration 2021 CR 8070, County Court cause number 67886, NIMAG number 649008, CM number 96156. And this cause number as well, I'm going to show you what's entitled well, as soon as I have it, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. It's not in here. Mr. Cantu, did you review what's entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because each of these cause numbers are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Cantu. I wish the best for you.
Thank you.
All right, the court is calling 2019 CR 3013, State of Texas versus Jeremy Ray Raffinay. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Robert Mauer for the defendant, Your Honor.
And are you Mr. Rothene?
Yes, ma'am.
All right, we're here for sentencing. You received a guilty verdict from the jury. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
We have, Judge.
Any objections to the PSI report from either side?
No, Your Honor.
No, Your Honor.
All right, state.
Your Honor, we don't have any witnesses. We just have argument. We'll reserve.
All right, defense, I'll hear your argument then.
Judge, I'm sure the court remembers this trial. I was frankly stunned that any jury in Bexar County would have convicted Mr. Rothene on the facts and the testimony that was put in front of it. Both with the testimony from the complainant that contrasted with the testimony from her own mom. The detective, I think, did a poor job working the case up and presented the evidence. I think the court should take that into consideration when assessing punishment. Of course, it doesn't matter what I think that he was convicted by a jury, but the court recalls, I think there were a lot of issues with what we had as far as the jury deliberations that led me to believe that somebody had made it onto the jury through some sort of deception. And I would ask the court to sentence Mr. Rothene to 2 years TDC based upon the facts of the case. As the court recalled, the allegation was a one-time touch over the clothes while the mom was out partying with her friends. And that was the entire case. Mr. Rothene's prior criminal history involves, I think, some state jail time for theft. Judge, I would ask the court to take that in consideration when assessing punishment. And I would ask the court to sentence him to 2 years TDC since he is not eligible for probation.
All right, state.
Your Honor, defense seems to have a different recollection of the case than I do. The court heard the testimony of Angelina Straub, Christina Bigler, Eric Mata, and Detective Stokel. I thought Angelina and her mother both came across as very credible and still very affected by what happened to Angelina that night. Now let's talk about the defendant's criminal history. Defense says that he did some state jail time for theft, but he actually did more than that. So in 2016, he spent 13 months in a state jail facility for taking someone's car that did not belong to him. In 2017, he was confined for 12 months for another theft in Comal County. And in 2019, he was sentenced to 4 years in prison when he screwed up his probation again on a case where he'd taken someone's property that did not belong to him. So the defendant has a bad habit of taking things and touching things and people when he shouldn't. Let's talk about this case. He continues to show no remorse and makes no apology for what he's done. And defense may have their opinion about the trial, but the fact of the matter is a jury did find him guilty of the indecency with a child by contact. Now, Angelina had to wait 4 years. That is a long time in the life of the child. She had to stand in front of this court and be re-victimized. It was clear when she walked into the courtroom and started testifying that she was still very much affected by what the defendant did to her. And think about how frightened she was that night when she texted her mom. He violated this family in the worst way possible. Christina Bigler thought she met someone who cared about her and her kids, someone that she could trust, someone that would help her. Think about what it was like for her to get those text messages that night, how terrifying that must have been. And she can't be here today because her child is sick, but you heard from them in the trial. We're asking you to sentence to the defendant to 11 years in prison so that for the next 11 years or the remainder of his sentence, he can think every day about how he's not supposed to touch children. 12 months wasn't enough. 13 months wasn't enough. 4 years wasn't enough for him to learn to be a better person. Give him 11 years, 1 year for each year of Angelina's life at the time he molested her. Let that be a daily reminder to him that what he did was wrong, and we are going to hold him accountable. And that when you decide to touch a child's vagina, it's going to be taken seriously and you will be punished.
All right, Mr. Rothene. The court will sentence you to 8 years in the prison. Give you credit for any time served. And there should be chapter 62 registration, that's lifetime registration. Do you understand? I'm sorry.
Yes, ma'am.
All right, I'm gonna show you what's entitled. I'm sorry, is there anything else on either side with regards to sentencing?
No, Judge.
No, Your Honor.
All right, Mr. Rockaway, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, you have a right to an appeal since this is a jury trial. Do you understand?
Yes, ma'am.
Mr. Mauer, if you're not going to,
I filed a motion for new trial. But I think I didn't need to withdraw and have the appellate public defenders. I'm not sure if I can handle the motion for new trial because I also filed a motion for the court to disclose the juror information. So I could have an investigator look into whether or not anybody on the jury gave false information or testimony during voir dire. But I'm not sure if the court wants me to do that or just withdraw and let the appellate defender's office do it.
it's however you wish to proceed, Mr. Mauer, but you'll need to let Ms. Ferguson know. And if you're planning on withdrawing and he's planning on asking for appeal, then of course that needs to be done as quickly as possible.
I've got the motion for new
Before
trial
30
filed
days.
already. We'll file the notice of appeal as well.
All right, thank you. All right, are the parties ready on Marla Garrison? Good luck, Mr. Rockaway.